Good evening, everybody. How does that sound? Everyone hear me okay? Sound man, hello back there. Could you turn the mic up? I'm right. Thank you so much. How's that? Better, better? More. More, says the crowd. More. Can't get enough of me. I've only just started. Hello, everyone. For those of you who don't know me, I am Margaret Coker, and I am the editor-in-chief and the co-founder of The Current. We are celebrating our 5th year anniversary at the end of this month. We are coastal Georgia's largest, but we're also largest news organization. We're also the only nonprofit investigative public watchdog newsroom. We are celebrating our 5th year anniversary, and we are so glad to see you all tonight. We have some great VIPs. And we are putting on this event with a very prestigious organization as well. And Ari Middleman is going to tell you about our co-host for the evening.
Well, thank you, Meg, and thank you to our judges who've traveled from near and far, and thank you all for joining us. It's been great to meet many of you over the last few minutes. What I've heard over the last few minutes is what is Keep Our Republic, and that is exactly our mission, to help keep our republic. We were founded in the spring of 2020, but I want to take you all back to this day 238 years ago, September 17th, 1787. This is my first time in Savannah. I want to thank you all for your hospitality, but more than 20 years ago, I had a condo in Old City, Philadelphia, and I know it's heresy to compare your colonial neighborhood to Philadelphia's colonial neighborhood. I'll admit I'm from north of the Mason-Dixon originally, but anyhow, on that day, September 17th, 1787, the temperature was probably right about like this. It's rumored, and it's become urban legend, that Dr. Franklin emerged from Constitution Hall, and a woman approached him right there on Chestnut Street and probably didn't say y'all, but said, "What were you, good sir, doing in there all summer? What type of government have you given us?" Because they kept it quite secretive what they were doing, the delegates of the Constitutional Convention. And Dr. Franklin said, "Well, ma'am, we've created a republic if you can keep it." And I think that's something I wake up and think about each week as I run this great nonprofit, because it really does take an active citizenry. I just met great high school students who I don't even think are old enough to vote, so I think we should all give them a round of applause. And I am super grateful for everyone coming out. This initiative within our nonprofit, we refer to it as the Article 3 Coalition, referring to the 3rd article of the Constitution. I think we all believe in checks and balances. To learn more about the judiciary branch, our goal as we're kicking off a national town hall tour. It's been a long day. Town hall tour. We're going to Harrisburg, Pennsylvania. We're going all over the country. Is to humanize the judiciary and really speak up. Sitting judges cannot speak up other than through their decisions. And I know there's been a lot of questions from average everyday Americans about the judicial branch. So thank you all. I'm looking forward to learning a lot. I guess I'm handing it back to you.
Yeah, thanks. I see a lot of familiar faces in the crowd, but just in case you have not subscribed to receive the Current's newsletters, please know that as a nonprofit news organization, our mission is to provide in-depth, data-driven journalism that provides us all with trustworthy facts and empowers us to become more civically engaged, to solve the shared problems that we have here in this part of Georgia. Part of being donor-driven as a nonprofit is that people who give us money believe in the mission that we are publishing trustworthy stories full of integrity, but also they believe in the mission that we have, which is provide this kind of quality news for free. So when I say subscribe to our newsletters, what I really mean is give us your emails so we can send you our 5 times a week newsletters. Tonight, because of one of our sponsors, we have the ability, if you give us your email, you have the chance to win a $250 gift certificate to the Gray just around the corner. So if that doesn't entice you, if high quality news doesn't entice you, high quality food should. And with that, I'm going to say we also have some great merchandise in the back. If you feel flush and you need Christmas presents, I have to always be selling, because you know what? To do high quality news, it takes a whole lot of money. And you can meet some of our reporters here in the back. But for right now, I'm going to hand the mic over to one of our board members, the amazing Richard Griffiths, who has come from Atlanta for the evening. And I can go through all of his laudatory professional qualities, but it is also in the program. And I think we're here to see the judges, not to hear about us. So without further ado, I'm going to give the mic over. Thank you for coming.
Thank you, Ari and Meg. Welcome to an evening where we're focused on the rule of law. So there are some rules. We'll be coming into the audience in a little while to take your questions. We're going to be looking for short, sharp questions, not speeches. I've got a lot of questions for this panel, and we're going to slip through as many of them as we can, as fast as we can. But these are judges, and you know about judges. They have power, and they have the microphone. So we're going to work our way through this together, and hopefully after an hour and a half, we will be educated, informed, and perhaps encouraged to speak up and take action. So let me start off with our distinguished jurists. The first is Justice Vanessa Gilmore. Judge Gilmore was born in New York City. She was raised in Maryland before moving to Texas after college. She was sworn in as the youngest sitting federal judge in the nation after being appointed by President Bill Clinton. Working in the Southern District of Texas, Judge Gilmore issued decisions on intellectual property, product liability, securities fraud, energy, utilities, insurance, environmental law, and handled the trial of the Enron broadband case. That was a blockbuster. Judge Gilmore is the co-author of A Boy Named Rocky, a book for children of incarcerated parents. She's a frequent speaker on issues related to these children and has worked on initiatives to help them and their families. Judge Gilmore was a civil litigator before being appointed to the bench. And a fun fact about Judge V, she owns a tea room called, naturally, Tea with Judge V. Judge Beverly Martin was born in Macon. She's a fourth-generation Macon lawyer and UGA graduate. She was a judge on the U.S. Court of Appeals for the 11th Circuit from 2010 through 2021, appointed by Barack Obama and approved by the U.S. Senate in a 97-0 vote. Prior to joining the Court of Appeals, Judge Martin sat for nearly a decade as a U.S. District Judge for the Northern District of Georgia, and from 2021 to last year, Judge Beverly Martin was the Executive Director of the Center on Civil Justice at NYU Law School. Before she became a judge, she was a federal prosecutor, including as U.S. Attorney for the Middle District of Georgia. Beverly now volunteers at a Los Angeles-based post-prison reentry program where she helps former inmates with legal matters. Judge Ursula Ungaro was nominated for the Southern District of Florida by President George H.W. Bush. In 2018, Judge Ungaro ruled in Gubarev versus BuzzFeed that BuzzFeed had not committed defamation in printing in full the Steele dossier, news that was very important for me because I was at CNN and we were dealing with a lot of the stuff relating to the dossier. In 2012, Judge Ungaro ruled that an order issued by Florida Governor Rick Scott to randomly drug test 80,000 Florida state workers was unconstitutional. And in 1998, Judge Ungaro ruled that an establishment clause challenge to the 1954 congressional addition of the words "under God" to the Pledge of Allegiance was, quote, so patently lacking in merit to be frivolous. Fun fact about Ursula, she first went to Africa 20 years ago, is about to go back, as I understand it, been back every year since. She says she's never as relaxed as in the bush looking up at the Milky Way. And after hanging out with one or more than one pride of lions, I expect this session will be relatively relaxing. As I said, my plan is to ask questions for about 40 to 45 minutes, then open the floor to questions before coming back for some concluding comments from some of the judges. Judge Gilmore, let's start by defining some terminology.
All right.
What's the law?
Very good question, and I think that's a perfect place to start because we are often talking about the rule of law. And the rule of law means the Constitution of the United States, the laws passed by Congress, the opinions of judges, and everything down to the ordinances passed by municipal entities, even the water board, the dog catcher board, everything that it governs the way that we conduct ourselves as citizens in this country is what the rule of law is.
So, Judge Ungaro, rule of law means a lot of different things to different people. How would you explain it? Hold that mic close. The power, no, it is not on now. No, you don't have to hold it. It should now be on. Let me see. It is now on. You are now empowered.
Okay. So, obviously, what Judge Gilmore described is what the law is, but to me, the rule of law is more the consensus among the people to abide by the laws that have...
Hold it close to your mouth.
Is more a consensus of the people to abide by the rules that were first promulgated by our founders and the laws that have since been promulgated by our legislatures, by our municipal bodies, and so forth. To me, when we talk about rule of law, what we're really talking about is deference to the need for an orderly society and orderly communities.
Judge Martin, how does rule of law play out in the real world in your courtroom?
And I don't have a courtroom anymore, but I spent 21 years in a courtroom. And I come from a line of lawyers. My joke about it is we have a genetic defect in my family. We just go to law school. So as a young person, I remember going to court, and I remember being struck even then that whoever you were who brought your problems to the courthouse, whatever house you woke up in, whether it was a fancy house or a not fancy house, whatever stature you had in the community, you left all that behind when you walked into the courtroom, and everybody walks in equal to one another, and the obligation is on everyone to prove their case with the same rules applying to everybody. And it struck me at the time that that is a majestic system. And after having spent 21 years there, I still feel that way about it.
Judge Gilmore, what happens if people no longer trust in the rule of law?
If people don't trust in the rule of law and people don't agree to be bound by the laws that govern a republic, then in every country in which there was a democracy where people began to have a lack of trust in the rule of law, those countries have descended into dictatorship. They have descended into anarchy, and it is a slippery slope to an authoritarian regime where persons who decide that they know or believe that they know what the law should be and not what the law is take control of society.
Let's talk some nuts and bolts for a little bit. Judge Martin, what's the difference between a federal district court judge and a circuit court of appeals judge? You did both.
I did. I did, and it was a privilege. I still am scratching my head about how I got to do all that. But district court, you're very much in the mix with the parties to the dispute that you're overseeing. So if it's a criminal case, you're there with the person who's sitting in lockup and brought into the courtroom, and oftentimes his or her mother or spouse and or children. So you're very much in the mix of, this most important thing that's going on in this person's life. The Court of Appeals, you don't really see it's a much more controlled environment. We would hear oral argument in the 11th Circuit, and only about 15% of the cases filed in that court. Everything else just goes through on the papers. And then, for the cases, even the ones for which you have oral argument, the parties are often not there. You just hear from the lawyers in a very, time-controlled situation. But you have to decide the case with two other judges, which was a growth experience for me.
Well, let's talk about that. How do you get three judges to reach a decision? How do you win over colleagues in a time when society is so polarized? How did you do that?
Well, I didn't always win people over. But, I was raised in Macon, Georgia by a mother who grew up in Macon, Georgia, and her favorite thing to say to me was, if you can't say something nice, don't say anything. Well, that didn't foster, a debate in my household. So here I arrive at the 11th Circuit, and every case we decide, I have to decide with two other people. So I had to develop some skills. and what I learned was that my happiest days on the court were when I could pick up the phone. If there was somebody in my courthouse in Atlanta, I could walk to their chambers and see them. But the 11th Circuit covers Georgia, Alabama, and Florida. So I had some colleagues that I had to reach out by phone. And I learned to just call them up when they had circulated an opinion to me that I didn't think was right. And just, very respectfully, without ascribing motive or, discounting their intellectual effort. I don't understand this. Here's why this does not seem right to me. And, they would say, they would explain it to me. Okay, this is why I do think it's right. And I learned, even in a way I think my mother would have approved of, to have that discussion. And it was very rewarding for me, even though I often times, was not able to prevail because it's well, we can talk about that later. But, I would often hang up the phone and say to my colleague who I had not persuaded, thank you, you made me a better judge today by talking that through with me. And every now and then they would say the same thing back to me. It was very rewarding, and I think as something, a skill we can use in a lot of places. Don't attribute motive to somebody that you haven't talked to about what they're doing.
Judge Gilmore, courts are retrospective. They generally look backwards at things. They're not looking like policymakers forward. They're looking backwards. Judges can't generally anticipate a problem on rule on it, can they?
No, we can't anticipate a problem. We have to have an actual case in controversy before us. We can't give advisory opinions or say what we would do on an issue that is not before the court. That invokes the issue of ripeness. A case has to be ripe. That means it has to actually be before the court for consideration before we can give a ruling or opinion on it. So, and when we get cases before us, you're right, we do look at it sort of retrospectively. What did the law that is applicable here intend to happen in this case? How have these people complied with the law or not complied with the law? Sometimes we have to look at the legislative intent to try to figure out what Congress meant when they enacted a particular law. And so we are looking at issues that are before the court, ripe for consideration, where there is standing. That means that the people that are before the court actually have to have the right to bring the causes of action that are before us. It can't be somebody who doesn't have, as we would say in Texas, a dog in the fight. It has to be somebody who actually has an interest in the outcome of the case. They can't be there trying to figure it out for somebody else that has an interest in the case when they do not.
Judge Ungaro, have you ever heard a case that went against the government or an administration?
Well, of course, actually, you described one of those cases where I'm still having trouble.
Press it, and you're on.
Okay, there. So I had a case in which the governor's order requiring drug testing of 80,000 state employees was challenged as being unconstitutional under the Fourth Amendment. And actually, I got reversed by the 11th Circuit.
See, that's what they do. They just grade our papers. Trial judges, we're the real judges, and then they just come and grade our papers.
Right, but only sort of. So I ruled that the executive order was unconstitutional. The 11th Circuit reversed and said I had to look at all 80,000 positions more or less individually in order to make that decision.
Easy for us to say. Right?
Yeah, right. That was exactly my attitude. So my answer to this was, obviously the positions broke down into classifications, and I appointed what's called a special master to go through all.
So the special master effectively enforced your. How
Yes.
did the special master enforce your decision? How do the courts actually get your decisions enforced?
Well, I never personally experienced a situation where a government lawyer actually defied a court order. I left the bench in 2021, and after 34 years on the bench, and I just never confronted a situation like that. There was always sufficient external coercive mechanisms and also internal coercive mechanisms to bring about compliance. There are what we call sanctions, the threat of punishment, threat of contempt. There are peer review committees. There are complaints to the bar. And when it came to government lawyers, there was also the Office of Professional Responsibility within the Department of Justice that we could complain to and would take action against lawyers who did not have respect for the courts and for the rule of law. There was, at that time, the Department of Justice was very concerned about the integrity of their lawyers and the role that they're supposed to play in the administration of justice, which is to say they're not supposed to be there, especially the prosecutors, they're not supposed to be there to get a conviction. They're supposed to be there to represent the interests of the people.
So Attorney General Pam Bondi said in a June 25th statement, President Trump's executive authority has been undermined since the first hours of his presidency by an endless barrage of injunctions designed to halt his agenda. This pattern of judicial overreach undermines the democratic process and cannot be allowed to stand. Does the White House have a point? Are courts getting in the way of what he was elected to do, Judge Gilmore?
Absolutely not. You have to think of our democracy. I'm sorry, was I too blunt? You have to understand, our democracy is like a three-legged stool. And each of those legs of the stool are responsible for maintaining balance in our society: the legislative, the judicial, and the executive branch of government. The judicial branch of government is given the responsibility of looking at laws passed by Congress and determining whether or not they are constitutional. When someone acts in an authoritarian way and just enacts laws that they wish were the law of the land, but are not, the judiciary likewise has the responsibility to look at those laws and make a determination about the constitutionality of those laws. And so the judiciary's responsibility is no less cannot be less, because the laws that are being enacted are executive orders by the executive branch of government. If the judiciary fails to carry out its responsibility to look at laws and determine the constitutionality of those laws, then our stool is completely out of balance. If Congress passes laws that are unconstitutional, the judiciary has to push back on those. If the executive branch of government is espousing orders that are similar to laws that are likewise unconstitutional, then the judiciary has the responsibility to push back on those as well. Otherwise, our whole stool is out of balance and our democracy topples.
Judge Martin, isn't Bondi right to an extent? You're all appointees of prior administrations. The current serving judges, most of them were appointed by previous administrations. Doesn't that automatically mean that they bring bias to the table?
No, it does not. When I heard that, it made me think of all the people I've been privileged to meet who are serving as federal judges. And without exception, really, they're smart, talented people who are really trying to do the right thing. And I think especially when the press is in their courtroom, they're especially conscientious, but they're always conscientious. So, if you're losing all your cases in federal court, I don't think you can blame that on the judges. I mean, it may be time to evaluate the merits of the cases that.
So a follow to that is the Supreme Court is now curbing the ability for federal district court judges to issue nationwide injunctions. Not only is scope inherently limited by topic, but now also by locality. How does that affect the separation of powers between the administration, the Congress, and the judiciary, Judge Ungaro?
Well, I think nationwide injunctions were. I don't know why I'm having trouble with
There you go.
No,
You
just
got it.
talk into
this one. Okay. Oh yeah, it has a light. All right. I think nationwide injunctions were controversial before the Trump era. The Biden administration challenged them, for instance. It is an extraordinary use of power to impose a nationwide injunction on the constitutionality of a statute. I don't have a strong position on whether there should be or there shouldn't be, but there are other procedural vehicles that can fill the gap. And so I'm not as concerned about the CASA decision, which ruled, in which the Supreme Court, in an unpublished shadow docket decision, limited the ability of courts to issue nationwide injunctions.
Well, let's get into shadow docket. Yeah, go ahead.
Well, I want to just follow up on the point about the nationwide injunctions. I mean, there have been nationwide injunctions in every administration. The Justice Department looked at this issue back in 2020. In the George H.W. Bush, there had been 12 such nationwide injunctions issued during the Obama administration, about 19. And during the first Trump administration, 55 nationwide injunctions were issued. In the CASA decision, the recent decision, Trump versus CASA, what the Supreme Court said essentially is that no judge could issue a nationwide injunction that was greater than necessary to afford the litigant before it the relief that was needed. It didn't completely bar the idea that there could be a nationwide an order issue that would have some nationwide impact or effect, because there are still other avenues for litigants to get to the kind of relief that was being discussed in the CASA case, short of a nationwide injunction. There are other avenues, but I don't read that order as a complete ban or a bar for a nationwide applicability of an issue. The court just said that they could not issue an injunction that was greater than necessary to afford the litigants relief.
The Supreme Court, Judge Ungaro, has been issuing a large number of decisions through the so-called shadow or emergency docket. No hearings, just briefs, then a decision, often a very limited or no explanation of the reasoning.
Unsigned.
Sometimes there are no briefs.
Yeah.
Right.
They do it before the brief even gets there.
Let's talk about that. You say no briefs. Could you get away with that in the appeals court?
No, and I think it's bad for the courts. We are accountable for the decisions that we make in, after all, the most important things going on in someone's life, and they are entitled to know why we are ruling the way we're ruling in their case. I think it's really damaging to the court. And this whole thing about we're not going to rule whether it's legal or illegal, but you can keep doing it for now. I think it's just damaging to everybody's sense of what the courts are.
Judge Ungaro, how does that affect the ability for the lower courts to follow the reasoning of the Supreme Court? How does that affect trust in rule of law?
Well, in a lot of ways. I mean, first, there's this controversy about the precedential effect of these orders. It was the judge in the CASA decision, I think, right, that was criticized by the Supreme Court justices for not having followed one of these shadow docket decisions, when in the past we've always viewed those decisions as not having precedential value. So that's a problem. The other problem is the courts, for their legitimacy, rely, or traditionally have relied, on transparency. And part of transparency is writing opinions where the judge explains the reasons that they have relied on to reach their decision. And the lack of transparency is very corrosive, it seems to me, of the reliance that people can have on the integrity of the courts.
So this is sort of like the kind of parenting you sometimes see, or as if you've ever been a frustrated parent, because I told you so,
Right.
and it's not necessarily effective in child rearing.
Right, something like that.
Judge,
Why, Mom?
how does that affect the trust, though, in rule of law?
Well, that was what I was just trying to say. Perhaps I didn't say it very well, which is that part of the trust is being able to read and see. Read and see exactly what the basis was for the rulings.
Judge Gilmore, let's talk about physical security. Did you have U.S. Marshals in your court?
Absolutely, all of the time.
Did you rely on them?
Absolutely, and particularly when you felt like you were facing a threat for some reason.
Did you ever feel that you were in a threat situation?
From time to time. Most often in cases involving tax scofflaws, people who didn't want to pay their taxes, they would come in. I always asked for extra security on the days that we had those people coming in, because they would come in and they would say, "You're not a real judge, and I don't have to do what you say," and then they'd read you this stuff that they'd gotten off the internet about the Fourth Amendment. I say, "Stop reading me that stuff." But I had one crazy case where this woman starts reading me this stuff, telling me, "You're not a real judge," and I was like, "Okay." And she says, "What's happening?" I said, "You don't think I'm a real judge, but they do." And so, she was on a walker, actually. They handcuffed her to her walker and took her out. And then I called her husband up and I said, as she was leaving the courtroom, I said, "Tell your husband where the tax records are." And she said, "In the blue duffel bag, in the white pickup truck, behind the seat." And so then she leaves and he comes and I said, "Did you hear what she said?" And he said, "Yes." And I said, "If you don't go and get those records and bring them to the IRS today, your wife's not getting out of jail. Do you understand?" And he said, "I understand." And then he left. And then a few minutes later, my staff comes and gets me up my chambers, and they said, "There's a fight in the hallway." I said, "What is it?" He said, "You read the whole thing wrong. He was there with his new girlfriend, and the sister of the woman I sent in jail was beating him up, saying, 'You're going to let my sister stay in jail.'" I'd read the whole thing wrong. So I brought him back in. I said, apparently I've misread this whole situation. If you don't get the documents in the blue duffel bag and the white pickup truck and bring them in, you're going to jail. Do you understand now? He said, "Oh, I understand now." He was just going to let her go. You have to read the room.
That's a fun story.
Yes.
But we've had the son of a judge hurt, killed.
Mm-hmm.
We've had pizzas delivered to the homes of judges.
Absolutely. And delivered to the homes of judges and being told that they are from Daniel Adderall, which is the name of the son of our colleague who was killed. So it is a clear intent to threaten the judiciary.
Given the mood in the country following the Kirk assassination, the shooting of the the speaker in the Midwest, how has, sorry? Yeah, Minnesota. How has that, based on your conversations with colleagues, how has that changed what's happening in the courtroom and concern about their actions?
Well, I think that, for one thing, there has been, during the last several months, an unprecedented attack on federal judges, verbally, physically, and I think that it has caused a lot of concern among my colleagues. I spent last weekend at a conference with one of my colleagues who is on the D.C. Court of Appeals, who's been a recipient of some of those pizza deliveries, and it has the vitriol and the animosity that's expressed towards the decision of federal judges and the accusations against federal judges that are unfounded and based on nothing more than a disagreement with a decision that is being made has put federal judges at risk. And my fear, really, is the chilling effect that it has on judges in terms of them doing their jobs and them having a legitimate fear of whether or not a decision is going to subject them or their family members to violence. Judge Boasberg in D.C., who told him to turn the plane around, I guess they couldn't find his house, but they found the house of his adult daughter and sent the pizza delivery to his child. Now, she doesn't have any marshal protection. And she's an adult and lives somewhere on her own, and they figured out how to find her and deliver the pizzas to her home. So the threat against judges, the vitriol and the unfounded attacks, I think creates an atmosphere that is designed to scare federal judges, chill their efforts to abide by the rule of law, and legitimately puts their families in danger because, as we've seen in this country, there are people who, as we would say in Texas, are kind of one taco shy of a combination plate, and they're willing to do whatever they want to do to promote whatever their worldview is at the time.
Judge Martin, we've seen some judges lose patience recently with Justice Department lawyers over something that sounds pretty esoteric, the presumption of regularity. Judge Paula Ginis in the Abrego Garcia case complaining that her orders were flouted. This has been the process since day one, the judge thundered. You have taken the presumption of regularity and destroyed it. What is that, and why do citizens care?
I really don't know what that is. In my courtroom, everybody walks in with the same presumption. I don't presume that one person has the right position. So I don't know. I mean, there are obviously norms that we observe in our government, and one of the norms is that when a federal judge tells you to do something, even if you don't like it, you go do it. And so maybe that's what she was talking about. But
so we were talking about this morning, and actually, I think none of us have ever had anyone argue in front of us that we should adhere to the presumption of regularity. Now, are there situations where you're kind of forced to rely on the government? For instance, in criminal cases, when it comes to discovery, have they turned everything over that they should have turned over, or to the defense or not? Things like that. But no one ever argued to me that I should defer to the executive because the executive is the executive.
And the only time that I've had anybody make an argument similar to that was as I mentioned to you earlier, the death penalty case, where the defense was arguing selective prosecution in a death penalty case, and the government's argument was, you should just assume that we were doing the right thing by only indicting this person, as opposed to all the other 13 other people that you have involved as defendants in this case. And that's the only instance in which the government has actually made that argument to me. But I'm with my colleagues here. I don't presume that anybody gets a leg up or more consideration or more should be given more credence than anybody else. Everybody comes in equal, and other than that one death penalty situation, I've never had anybody even raise it as an issue.
Judge Ungaro, let's talk ethics. When the public thinks of lawyers, ethical is not usually the first descriptor that comes to mind, but this is the only profession where all the participants, lawyers and judges, sign an oath to the Constitution. How's that enforced?
Well, in the first instance, it's enforced by the bars, but that's a little problematic when it comes to government lawyers, because in many jurisdictions, the government lawyers don't need to be members of the local bar. So, and in fact, even in some jurisdictions, the lawyers, government lawyers, get a certain grace period before they even have to be a member of the bar. So, obviously, we look to the bars to regulate the conduct of lawyers as well as the courts, but the bar associations have that principal responsibility. And it's important that they exercise that responsibility. I'm becoming concerned that they are not as zealously enforcing the ethics rules as they should be. I think time will tell, and we'll see.
Well, we have seen some of the attorneys who represented the president disbarred. Action has been taken in some of those cases.
Yes, that's true.
even in Georgia, for
Right.
one.
Right.
And did Giuliani lose his license as well? Giuliani lost his license.
To the three of you, and I'll start with Judge Ungaro, what does a judge do when a judge is witness to injustice?
So, I think
Maybe we'll have a brief pause for the fire trucks.
So the good judge would say that he or she works within the system somehow to correct the injustice. The bad judge that I sometimes was sometimes pushed the envelope and tried to proactively correct the injustice. Admittedly, I didn't do that until I was pretty late in my career and not likely to be, or if action had been taken against me, it wouldn't have been something of very important to me. What was more important to me was correcting the injustice. So actually, what I have in mind is maybe in the mid-90s, I sentenced a woman to mandatory life, meaning I was required to sentence her to life in prison, no discretion. And in the federal system, when you sentence somebody to life, there's no parole. You die in prison. And I felt at the time that it was really an injustice that that I had to impose this sentence upon her, and she was going to have to serve the sentence. And when it became known that President Obama was going to be doing commutations, I contacted the Public Defender's Office and started to work with the Public Defender's Office actively to get this woman out of prison. And ultimately, the lawyer who worked on the case principally was one of my former law clerks, and ultimately she succeeded. Well, actually, she was in the second round. This defendant was in the second round of the Obama commutations, and she was released. To me, this was probably the single most rewarding experience that I had as a federal judge. It was just so, it just felt very good to be able to correct this problem. But the other side of it is she spent 25 years in prison while her 3 small children were growing up. Now, should I have done that? No. Judges aren't supposed to do these things. Did I feel compelled to do it? Yeah, I did.
Judge Martin had something to say to that.
I mean, it's a legal process. I don't think you did anything wrong.
I don't either.
Yeah.
I mean, actually, I really don't.
Well, but judges are not supposed to become advocates.
And I think that's right. We call balls and strikes. We don't have
Right.
we don't have a dog
That's
in the
right.
hunt, right?
That's right.
So right now we're at a place where the room probably has a lot of questions to ask. I'm going to ask one final question for this round that will tee up the questions perhaps from the audience. There's a lot of talk, a lot of fear that we are in a constitutional crisis already. Are we? And if not, when and how do we end up in a constitutional crisis? Judge Martin, would you start off?
I'm worried. I love this country. I have seen the federal courts from the inside, and I think it's a valuable thing for our country to have. And, of course, we've got some great state court judges here that do, day in and day out, God's work under difficult circumstances. So, I don't want to lose that. And what else needs to happen before we're in a constitutional crisis? I don't want to find out. I think it's time for us to go to work together to remember what we love about this country, what makes it great, and to help each other. I mean, there are not enough islands in the world for us to all go off by ourselves and be marooned and make our own rules. We have to live together. There are people who are suffering, people who need our help, and I think the more of us that can think about things in that mindset. I was talking to David Hamburger today. He's helping people with housing with the Georgia Legal Services. God bless you. And you know, I think the time has come for us to remember why our democracy is important to us and figure out how we can make it thrive. Because you know, it can be taken away.
Judge Gilmore?
Well, I don't know if we're in one yet, but we are on a slippery slope towards one. And by that I mean that judges have a few enforcement mechanisms to make sure that their orders, their lawful orders, are complied with. We can call the lawyers in and make them testify. We can, as Judge Ungaro already mentioned, we can place those lawyers for sanctions before the bar of the states in which we live and work. And then we can move forward to more serious consequences if orders, lawful orders, are not being enforced. We can hold people in civil contempt, which involves fines. Then we can ultimately hold people in criminal contempt. And if the lawful orders that are being issued by the judiciary, by the federal judiciary, relate to the executive branch of government and the attempt to enforce in an authoritarian way or impose upon the American public laws that the judiciary knows to be unconstitutional, the ultimate remedy that the judges have is to hold the executives in criminal contempt. Now, if it hasn't gotten to that point yet, no one has actually taken that drastic step of saying this order issued appears to not be constitutional under our laws, and if you continue to enforce it, for instance, several examples recently, you cannot, the court has ruled that they should not have sent the troops into Los Angeles, or whoever they sent the National Guard into Los Angeles, that that was unconstitutional. But it happened already in the past. Now, if it happens again in the future, knowing that there has been a ruling, now given that ruling was only by a judge of the Ninth Circuit, but if it happens someplace else and another court rules that you knew that it was unconstitutional, you already had some indication that that should not happen based on the previous ruling of a judge from the Ninth Circuit, and there is a continued effort to promote and to push actions that are unconstitutional, then ultimately some judge may seek to impose that ultimate remedy. Now, if a judge decides that criminal contempt sanctions are in order, then that is an impeachable offense. And then that punts the ball to Congress to act to decide whether or not they intend to impeach the executive. And then it's out of the judge's hands, out of the hands of the judicial branch of government. Then it's punted over to the legislative branch of government. So none of that has occurred yet. We haven't gotten to the point where some judges said, this is worthy of criminal contempt, and referred it to the members of Congress to determine whether or not the impeachment proceedings should proceed. But given the apparent unwillingness of the executive to abide by lawful orders of the judiciary, it is something that could happen and something that might happen. And because in the past, the threat of contempt has been enough to keep members of the executive branch of government from continuing on with unconstitutional behavior, it has always worked, just the threat or the idea that you might be held in contempt. Nixon was almost held in contempt, and then he gave the papers. Truman was almost held in contempt for taking the steel mills during the Korean War, and just the possible threat of being held in contempt made him decide that he wasn't going to do it. And so in those instances, it was a scenario where people understood, or the executive branch understood, the importance of abiding by the rule of law and not pushing it to the point where there was a possibility that they might be held in contempt. It required them to have some moral compass that said, maybe that's a bridge too far. And so we have to reflect and think about whether or not we think that there is a moral compass in the current administration that makes them feel that they should not push it to the point where we might end up in that crisis.
Which brings us to questions. So I'm going to walk down. If you have a question, please raise your hand, and I will come to you with the microphone. I'm going to... Sorry, I saw that hand go up in the back first, so that's where I'm coming. Short, sharp question.
Executive orders when it comes to elections. Can you talk on that?
Scary.
Judge Angara?
Are you talking about what's going on in Texas now and about reapportionment, or are you
talking about the request on paper and the request of the removal of absentee
And the mail-in.
Right.
Yeah.
Right. Well, I don't know, maybe some of my colleagues here have considered the constitutionality of those specific provisions, but obviously the accessibility of everyone to be able to vote is a very important constitutional right. And we have relied on mail-in ballots and other methods of not in-person voting in order to accommodate people who work.
And we had those issues come up in Texas in one of our last elections. Well, actually, not one of our last election cycles, because I was still on the bench then, and I retired in 22. And those very issues came before the federal courts of Texas, in fact, my court in Houston, on mail-in ballots and drive-by voting and all of the things that we did during the pandemic to make sure that people were not disenfranchised. And every one of those orders that was issued by our governor at the time was ruled to be unconstitutional and thrown out, and we were able to do mail-in votings and drive-by votings and all of the things that we needed to do to make sure that people had the right and the ability to vote. So it's scary to me that those same issues that we've already dealt with, at least on a state level in Texas, are now before the courts on a federal level. And because I've looked at some of those issues, at least just on the statewide level, and know the unconstitutionality of some of those things, it's definitely a concern.
Judge Martin?
Yeah, I just wanted to say briefly, elections are run by state government. And so I think we need to remind ourselves, we need to, if you're here tonight, I suspect you're a regular voter. But I think we need to be very conscientious about who we're putting in positions in state election roles. And so we can hang on to that power. It's critical because, really what the Supreme Court has said is we're basically going to let the states do whatever they want to do. And so, we've been lucky in Georgia thus far as I know. So it's a state issue, and we need to protect that.
Question here.
Playing off the last question, I was always under the understanding that executive orders were a policy initiative, not the law. In the immunity decision on page 7, I have it right here, Justice Roberts chose 2 sets of 3 words and he put them in quotation marks. One was, if the president acts expressly on his mere individual will, in quotation marks, or his authority without law, in quotation marks. As judges, I'm assuming he chose those words very carefully, and I'm assuming I have a great deal of respect for the interpretations that you all do in your careers. How would you interpret the use of those 2 sets of 3 words in quotation marks, and why has no lawyer, no prosecutor, no judge mentioned mere individual will when they are trying to rule on his intent behind what he is doing?
Because the rest of the order is too broad in terms of the range of immunity that it provides. I understand you picked out some words that seem to limit that.
It's part of the Youngstown decision. In the Truman era, he chose that specifically because the Supreme Court denied Truman, as you know. So he chose those. I'm just curious why any lawyer that just doesn't want to throw SCOTUS's words right back at them.
Oh, in what context?
Mere individual will.
I know, but you say why no lawyer has
Executive orders.
okay.
What
But
he's doing to universities and law firms and individuals, he's just running amok because we all know why he's doing it.
I know, but to say that no lawyer has tried to push back, I don't think is completely fair. You know, since the beginning of the year, there've been 250 lawsuits filed challenging executive orders, challenging the immunity, if you will, of the president with respect to the issuance of some of these edicts. And so I think it's unfair to say that no lawyer has pushed back against that, because unless you've looked at all of these lawsuits, and we try with the help of Keep Our Republic, because we're asked about a lot of these lawsuits. All of us get media calls all of the time. And Keep Our Republic, one of the things that they do is they assist us in looking at the lawsuits and analyzing what's going on and trying to stay up to date on the nature of the lawsuits that are being filed, so that when we're asked questions just like this by members of the public or the media, that we have the ability to say, yes, there has been some pushback on some of that. So I think it's just not a fair thing to say that no lawyers have tried to push back on some of that.
And I don't want to be too lawyerly, but ultimately the president's power is determined by the parameters of Article 1. And so there are areas in Article 1 where the president has almost unlimited power, like foreign relations. And in fact, Trump is hiding behind that in his reliance on the Alien Enemies Act and his immigration policies. So when Justice Roberts is using the terminology, he's talking about where the president acts on his own whim, independent of the parameters that are established through Article 1. Not that any, that's not to say that the executive orders might not be arbitrary, but that's a different kind of concept than whether or not, I believe that's a different kind of concept than what Justice Roberts is referring to when he talks about the president operating on his own whim.
But are you saying that now executive orders are now law because that's the way we're being governed?
No, I'm saying in some areas the president has almost unlimited power. And when it comes to those areas, executive orders have the force of law.
Look, can I just quickly? It's a shocking opinion. I don't know any legal scholar who expected that from the court. But the most optimistic thing I have to say about it is, there's smart people like you who are thinking about this, and I don't think we've seen the end of it yet. I mean, I think maybe that was Justice Roberts' way of signaling, okay, this is not unlimited, but we're going to see it play out. So I hope they're reading what you're reading.
We have another question from the back.
It's not necessarily a question. I really
Not
did,
doing speeches today.
no, but in Georgia, yes, the right we did. We had a fair vote last time, and all that was wonderful. But there have since been laws enacted in the state of Georgia that gives almost anyone the right to question a vote, question a group of voters.
What is your question?
My question is, what can we do? We know it's coming. What can the state level do or the federal level to cut this off before it happens, if possible?
I mean, what do you think? I mean, I think we've got to be involved, and we've got to, hold our elected officials to account. It's scary. I'm with you, and I wish I had the perfect answer.
Well, there are organizations that in every election cycle, see as their role and responsibility to make sure that people have the ability to exercise their right to vote. Groups that train people to assist potential voters that have been disenfranchised and help them exercise their right to vote. And if you're concerned about that, then you need to be involved in one of those organizations.
Question here.
I'm just wondering, given the events of January 6, 4 years ago, can you give me any optimism that there's some checks and balances that have been put in place since then that we could be a little less concerned going into election time 3 years from now?
No.
Okay, if so, what do we do about it?
If so, what would we do about it?
Well, I mean, what that makes me want to do is thank you all for being here tonight, for caring about this. No, I think it's so important. And we had the privilege today of going and seeing Abraham Baldwin's handwritten notes on the copy of the Constitution that they were working through. And so it's always been a fight, you know, I mean, and we have to keep fighting.
One side wants dominance and the other side wants democracy.
Fight for democracy.
We have a question here.
Yes. So when we're talking about the idea of a constitutional crisis and the potential of criminal, what was the word? My mind just went blank.
Contempt.
How would the Supreme Court order giving the president immunity, how would that affect it?
We're going to see, aren't we? I don't know. That is going to be one side of the argument. One side of the argument is going to be you're in criminal contempt, and the other side of the argument is going to be, no, I'm not. Look what Judge Roberts said that I could do this. So that's the other side of the argument.
Question from the second row.
Yes. Is it possible that the Trump has a Supreme Court in his back pocket? And where is the head of the Supreme Court right now?
Like, where's the head of the snake? Let me just say this. I'm going to push back on something that my colleague Judge Martin said earlier today, and it was a question raised about bias and whether judges acted with bias, whether judges from previous administration might act with bias. I'm going to push back just a little bit in this regard. All of the judges, every judge I know, are those bats? Okay. I guess as long as you don't look like a bug, right, you're okay. Comes to the positions that we are fortunate to have with our own implicit biases. You know, it came to a head for me when myself and one of my colleagues were both sentencing Enron defendants. And there was an article in the paper. We talked about what happens when there's only one paper in a town. They can write whatever they want to. And which they said that my colleague had said that the defendant didn't need as much time because of the community he came from. It wasn't important for him to get jail time. So I read that statement and I thought, oh, they must have misquoted him. So I went to my colleague and I said, did you really say this? Because this doesn't sound like you would have said this. And he said, well, no, Vanessa, what I meant was, you know, he's from our neighborhood, River Oaks, the nice neighborhood, and you know, he's already embarrassed in his community by having, you know, been convicted of this crime, meaning, you know, like he can't go to the country club anymore. And he said, and he's in the Boy Scouts and everything. You know, our other defendants in their neighborhoods, everybody goes to jail, so it's no big deal for them to go to jail. I was like, that's worse than what it said in the paper. And I told that story at a sentencing conference, and as a result, I was asked when the Sentencing Commission came out with a study on showing implicit bias among federal judges in terms of sentencing and how our minority defendants were getting 19 to 20% higher sentences, all factors being equal, after we were no longer bound by the sentencing guidelines. We used to be bound by the sentencing guidelines, but after a couple of cases from the Supreme Court, we had a discretion to go above the sentencing guidelines, below, or sentence within the guidelines. And what happened was the sentences were disproportionately unfair to minority defendants. And so they tricked me into coming out to San Diego, presumably to give a speech about recidivism in my little book about children of the incarcerated, and they hand me like this 600-page study and said, read this and give a speech about this tomorrow. So I stayed up all night, and I gave a speech to my colleagues on implicit bias in the courts. And I thought, because originally I said, why do I have to be the one to talk to my colleagues about this? And they were like, I said, I see how it is. You know, the black girls got to get up there and say to your colleagues, you know, y'all being racist. And they said, yeah, that's how it is. You know, you get up there and do that. Everybody likes you, whatever. So I did at this conference. And I got a lot of support from my colleagues saying, I need to figure out how to recognize when I'm guilty of implicit bias. I went home and rewrote the speech that I wrote in one night and made it better and more succinct and show the stats and everything. It is my most requested speech. I give my speech on implicit bias in the courts more than any other speech that I give. What I think we have to do is recognize that we all bring our own biases to the table and to try to make sure that we work as hard as we can to put our own implicit biases aside and not think, well, this guy's from our neighborhood and he's already been embarrassed by his community, and treat everybody the same.
I could not agree with that more.
That's right.
Right.
I don't disagree with anything you said.
Right.
We're going to try to get in a few more questions if we can. Judge
Okay,
Ankara,
I
you got
was
something
just
to
going to
say?
say all judges bring their own life experiences to the bench, and everybody has biases of some sort or the other. Good judges work very hard to put those biases aside and to decide the cases based on the law and the facts.
And I think the one thing that's happened, I mean, the Supreme Court is at its lowest confidence rate among the American public than it ever has been. And I think that one of those reasons is because this administration, in choosing the judges that they've had the opportunity to put on the Supreme Court, specifically chose judges that they wanted to have a particular bias before as a prerequisite to being able to be considered. And I think that is one of the things that has made people lose confidence in the Supreme Court.
Question from your right.
Well, thank you for being here and sharing your knowledge and for your long service to our country. Sorry you guys are no longer on the bench, but thanks for being here with us. So I graduated law school not long ago, and one of the big topics was judicial reform, and professors would get up and talk about all their ideas. But I'm curious to hear your ideas as folks who have intimate knowledge of our judiciary. What are some changes that you think we as citizens could be advocating for, just to name a couple, term limits, different selection processes for our federal judges, jurisdiction stripping. There's so many different ideas. What are some that you think are feasible and needed for our judiciary?
Well, all of those require a constitutional amendment. So good luck with that.
It does. I mean, of course, after seeing the notes of Abraham Baldwin today, I mean, they couldn't think of everything, right? But, I mean, it does make sense for every president to appoint a justice to the Supreme Court per, 4-year term. Or, people have worked all that out. It seems like, a much better system. And I think it would improve things a lot. Whether we can... I mean, you advocate for that, David. My money's on you.
Last question from the back row here.
Thank you. Given the volume and frequency of cases being filed by and against the federal court, how is it determined which judge and which court receives a case and the urgency with which it's addressed? Thank you.
Well, I think that to some degree it depends on the court, but all the courts have random, to my knowledge, every court has a random filing system that has integrity. Now, can people get around it? Like, for instance, in Florida, in the Southern District of Florida, which is where I'm from, We're divided into the Southern Division and the Northern Division. The Northern Division's Palm Beach and Fort Pierce, and maybe you know about Eileen Cannon, who sits in Fort Pierce. And she's the only judge who sits in Fort Pierce. And there's only 2 other active judges in Palm Beach. And so the lawyers who want Eileen Cannon play the odds, and they file in the Northern Division of the Southern District of Florida. So
and there's that guy in Texas too, right?
Yes.
So
absolutely.
there are random. The filing system is random, but you can game it to some degree.
That's what we call it forum shopping. You look for a forum where there's a single judge, and then you file in that district, in that division, so that you can get that judge. So that does happen.
I have no doubt that the Trump case against the Times was filed in Tampa because they were hoping to get a judge in Tampa who is very, very pro-Trump, more so than Eileen Cannon, Judge Mizell. Instead, it ended up with one of my classmates from law school, Steve Meriday, who's a pretty conservative guy, but it didn't end up with Judge Mizell.
Mm-hmm. So that can happen. But
my last question to the 3 of you, to each of you, is why did you give up 2 days, travel across the country, in some cases here, to spend an evening with these good people? Why come here now?
One of the things I think that we've noticed is that there has been an unfortunate lack of civic education for a lot of our young people. And I think all of us believe that it is part of our responsibility to try to promote an understanding of the courts. It's a means of civic education. And also because we are all retired judges, we're sort of unshackled at this point. We can talk about things that maybe our colleagues cannot talk about, and we can speak up on behalf of our colleagues who are facing unprecedented threats at this time. I think that we have an obligation, a responsibility, a duty, and I would dare say a privilege to be able to be before you tonight, and we really thank you for your presence here.
Quickly, I love my country. I had the privilege of serving on the federal courts for 21 years. It was a privilege that many people deserved at least as much as I did, and somehow I got to do it. And so, you know, if I can ever play any role in educating anybody about the importance of the independent judiciary to a democracy, I'm there for it. Can I just I want to. My second reason for being here is really, you heard from Ari Middleman. He works for Keep Our Republic, which was started as a bipartisan effort by former Senator Tim Wirth and former Speaker of the House Dick Gephardt, one Republican, one Democrat, because they care so much about bringing people together to support our democracy. And so thank you, Ari, for getting us involved in this. And thanks to you, Meg. I've been so impressed with you and what you're doing at the Current. And it's really been a privilege for me to be with you all.
I just want to echo what Beverly just said. It has been a privilege to be here. And by the way, your city is just gorgeous. It's really, really nice to be here. But I came because I have, like Beverly and like Vanessa, a tremendous affection for the courts, and believe that my colleagues work very hard to provide something essential to our society for the orderly functioning of our society, and I hate to see it corroded, and so that's why I'm here, to try to help to prevent that.
Thanks to all of you for coming. Before we go, I want to thank a few folks who made tonight work. To our friends at WSAV who have been streaming tonight's event, and I'm sure dealing with the terrible backlighting. We've learned a lesson for next time. We'd like to thank the League of Women Voters who recruited folks for tonight and helped us out in so many ways. Obviously, Keep Our Republic for doing such an extraordinary job pulling this great panel together. The Gray for their very generous gift for some lucky winner who drops a business card and signs up for the Current's emails. And, of course, the Current itself and the Ships of Sea Museum. So thanks to all of those institutions for making tonight, and thank you all for coming.